Let's welcome our guest for this hour, trial attorney Alexis Rosenberg. And I'm going to let you share with Alexis your question because you were supposed to bring her in, and I just bigfooted you.
And it's all good. Alexis, quickly, we both have something for you. But here's, when the attorney was speaking, the defense attorney, he mentioned to the judge that he didn't think he should take into account what happened after. And it's an interesting question because ultimately the jury found him guilty of the lesser charge of voluntary manslaughter. Big win for the defense in this case. But it's hard to turn your eyes away from the fact that he did take the actions he did after. But based on the jury's verdict, I understand what the defense attorney is saying. Should the judge take into account the idea that he made the decision after he killed this woman to dump her in a pond, and like the state said, dump her basically like trash?
I think you can't. I agree with you, Michael. You can't get away from the fact of what he did afterwards. The jury has convicted him for the actions leading up to that, but you can't get away. And I think that the judge is going to take that into consideration. I thought what was interesting is that the defense attorney said, I'm not going to ask for time served when he's been in jail for 5 years. And if she does end up sentencing to guidelines, then you add that 5 years. We're really exactly where the prosecution wants to land with sentencing anyways.
Alexis, let me ask you this. So the prosecution asked 14 to 17. They didn't get quite the top of that, and the defense 8 to 10, and the court went above what the defense wanted. But here's really where I'm going with this, Alexis. All of those numbers are fairly close. Isn't it already a big win that he was not convicted of murder and that this is for voluntary manslaughter? I feel like at the end of the day, he's already ahead of the curve, so to speak.
Judge Ashley, 100%. That's a huge win. If you've been charged with murder and you end up getting convicted for manslaughter, that's huge. And also, you know, they kind of split the time between what the defense was asking for and what the prosecution was asking for. But remember, he's getting that time served. So he is getting a lot of that time served credited to what he's been sentenced to.
You know, it's interesting, and I'm going to go a little bit further. Yes, it looks like he went in between the two, but I think the way to really look at it is the statutory recommendations were 8 to 10.
Yeah, he went above that with that.
And he went above that, and I think he went above that fairly significantly. So clearly he thought it required something more than what the guidelines suggested. But here's something we're just learning. The defense attorney said he's already been in jail 2 years. He has a chance of being released within 4.5 years from now, which means he's probably, what, about 64 years old? We're talking getting out when he's just before 70 years old. When you talk about a win.
Yeah, that's a huge win. I agree with you because, yeah, that's a whole different ballgame to say you're only going to serve 4.5 years versus you're actually going to serve 12. Yeah. Big difference.
Alexis, quickly, I mean, I tell you, we heard some of the, victim impact statements. That's got to feel like a slap in the face to this family. They were very, very, very angry at what this man did and certainly didn't buy what the jury did in this case.
I mean, they lost a loved one. Like the defendant said, they lost the mother, they lost their loved one, and 4.5 years is going to be exactly what you said.
Trial attorney Alexis Rosenberg, I want you to ring in on that same question about the judge sort of, again, I don't want to use the word rushing, but she certainly wanted to get this witness off the stand by the end of day today, which they were lucky enough to do.
He did this morning give a pretty stern warning to them that they needed to finish up by 4:30 today. And as Judge Ashley stated, they did finish early. So I think that they would have on appeal a hard time saying that they were somehow prejudiced by that. But potentially there could have been a motion for a mistrial if she wasn't able to finish and they weren't able to appropriately cross her.
Big thing this jury's going to have to decide is really the consent piece, whether or not she consented or was it force, intimidation, coercion. How are you feeling about that piece of it listening to this testimony?
I think it's going to be really hard for the jury, but remember, with the consent, she can consent and change her mind, and then we have coercion. So, but it does sound here that she did testify that she was afraid, which would give us that coercion, that she did it because she was so afraid to say no to him.
But Alexis, I have to ask you, what was the net sort of result of her testimony? Because I can tell you from looking at some of that testimony that was elicited on cross, specifically her own words and text messages, right up until the time she decided to leave this relationship, it really seemed like she was engaging in these freak-offs to gain his love. She thought this was the way to stay connected to him. It wasn't until she finally realized that that wasn't going to happen that she decided to leave. Sounds to me a lot like that was the incentive more than what she testified to.
I agree with you, Michael. The jury is going to have a real problem deciding which it was based on the testimony that was presented. But remember, at the end, she did testify that we had that last rape. And I think that was a very line in the sand, that she had called it quits, she was leaving him, and then we had that situation.
Alexis, talk to us about a person like a Cassie Ventura on the stand detailing such specific, horrific details about everything that she really almost ever did with this man. You can't even imagine how she could get up there and do this, the bravery and the ability to do it.
I agree. It took substantial bravery and just horrific. Your whole life, every bad, negative detail is just put out there for everyone. She comes across as very credible. You're believing her because she's just not saying things that support her position. She's telling you everything. She's telling you that I went back to him. I consented to going back to him. I still had feelings for him. So when she tells you the other things, it really does make you believe what she's saying. When she says that she was raped, it makes you believe that because she turns around and tells you, I did. I ended up going and I was with him again.
Alexis, what role do you think money is going to play as the jurors look into motivations? I think it complicates things. We heard about that $10 million settlement. They heard about it as well. We know how much money Diddy had and what that means for folks who are in his circle, right, or his girlfriend. That means you have a wonderful lifestyle. That could be part of the motivation as well. That's got to play into the minds of jurors.
Also, jurors that seem to usually like celebrities, and they want to find them not guilty. So we do have to overcome that as well. But the fact that she got money for this, and it is confusing, was she consenting, was she not consenting? But we do have the video. She was definitely physically abused. I think everybody can come to that agreement. And the hotel did not really follow the appropriate protocols. So I think she does deserve the money. And I don't think it shows some motivation that she's making this up for some ulterior motive.
Alexis, you know, Michael Proctor is really the head of the spear when it comes to the defense's claims of conspiracy. He's the guy. He's the guy. His name has come up so many times. One of the things I think the defense has done a great job, whether they decide to call him or not, is they've kept his name. I don't think a day has gone by in the trial where we don't hear Michael Proctor's name. The question is it enough?
First of all, that testimony, liar, liar, pants on fire. So he deserved to be in the hot seat there. I mean, why is he playing with semantics with the word relationship? So they are keeping it at the forefront. And the real question, like you said, Michael, are they going to call him or not call him? And they're going back and forth about that. I think they need to call him. I really do. But I do think it's going to be polished. I don't think he's going to be blatantly lying that initially that he didn't have a relationship.
It's just so good. Let's listen to a little bit more of what Michael Proctor testified to. Again, at the first trial, the Commonwealth has not called him. We don't know if they will, if the defense will. Let's listen to a little more together.
So these came from me. From all accounts, he didn't do anything wrong. She's a whack job.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Yes, she's a babe. Weird Fall River accent, though. No ass.
Right, again, he's talking about the defendant, Karen Reed, during the course of a criminal investigation, unprofessional. But Alexis, how can the defense not afford to have him testify if the Commonwealth doesn't? Because it's gold in terms of, I think it really makes it look bad.
I think they need to have him testify. It makes him look horrible. It's beyond unprofessional. It actually goes to his mindset, it goes to his personality, and it supports the defense's position. And they need to put him on the stand.
And it goes to his bias, I think, right?
Well, bias, I think, was the big problem here,
Yes.
more than all the other dumb stuff. I think that the appearance of impropriety is the problem. And my question for you, Alexis, is if I'm looking at this from the, if I'm sitting there representing Karen Reed, I've been able to get his name out there throughout the trial. We've heard the text messages through Buchanan, right? So we know about all that stuff. Why give him a chance to get on the stand and speak to it? I've got all this information out there. I can argue in closings that he had the opportunity. We saw him on tape at the car in the Sally Port. We heard his name mentioned. He's the one that, you know, didn't take something to where it was supposed to be tested for a month, kept people's names out of, you know, different reports. I can just use that in my closing without ever giving him a chance to speak to it at all.
That's true, you could, but I also think the jury likes to hear it from the mouth of the horse or the source, whichever one you want to say. I think putting him on the stand, I mean, he like said before, this is gold. He will come across more polished the second time, obviously, but I think the jury is going to want to hear from him.